everybody. Oh my goodness, it has been a day. It has been a day. Oh my gosh, coming in very late. I apologize. I'm still working on trying to get everything set up here. Doing my best. Yikes. Oh my gosh. Okay, so okay, well, welcome in everybody. Welcome to the madness. Oh my gosh, it's been a crazy day. Complete madness. I just can't even. Oh my gosh. Yes, it's just been a little bit bonkers. So, yeah, the crazy train keeps going, everybody. It's too much. Too much crazy, not enough train. Oh my gosh, but we'll make it through. We'll make it through. You can probably tell I've got the comments on tonight. I thought we could chat for a few minutes before I dove in. Oh my gosh. So, finding my seat on the train. Woohoo! Well, hello everybody. So, welcome in. We had, there was a lot today, everybody. Now, let me just start off by saying, I had originally planned to go through the mifepristone case that was just, the cert was just granted. Is it Stone maybe, or Steen? I can't remember. I apologize, but I had posted on talking about that particular case. And I'll tell you right off the bat, I'm not going to be reading through that case tonight, everybody. I had read through a bit of it, and I'm just not ready to do another abortion case. I'm just not, everybody. But let me give you a synopsis about what's going on with this case. And I do plan to read through it, but mifepristone. Okay, I do plan to read through it, but it will probably be, I just need a couple more days. It's been a rough few days here. So, but let me explain what's happened, everybody. So there were 3 lawsuits. First, we've got the FDA versus Alliance Hippocratic Medicine. Then we have Danco Laboratories. So these two together are the ones that cert was granted on. And then this third case was actually the Alliance Hippocratic Medicine versus the FDA, and cert was denied on that one. So the issue here that's up has to do with the second set of restrictions that were put into place on the appeal. So I think cases could be heard. Yes, very interesting. So, but anyway, I have started going through. We do have 2 cases here. They're not particularly long. When you just look at the writs as opposed to all of the appendices. So I have been reading through this, and honestly, it's just too much to do abortion cases back to back, 2 nights in a row, everybody. DC Circuit expedited immunity appeal. Really? Okay, that's interesting. By January 3rd. Okay, well, and that was the other, we had a couple of big things happen. So, speaking of which, we did have an opinion and an order that came out by Judge Chetkin. All right, now we were talking before about this motion to stay everything that was going on in DC. You know, we went through that. And so the judge has issued an order here. So about 45 minutes ago. Okay. All right. So they've expedited. Right. Yeah. And so I think this will be helpful for that, because she kind of sets out here that she wants to pause certain parts of it until the appeals take care of that immunity question. All right, so been glued to the news all day. So it's been a lot. So I have not read through this yet, but I do want to go through this with everybody. So this is the most recent order from Judge Chutkin. So she's kind of splitting it like she is one to do, and she's kind of splitting it 50-50. She's pausing things in DC, but also other things are going to go forward. So I will take you through that one tonight. Did we get a response to that wild thing we read last night? This is it. This is the response by the judge. Oh my goodness. Yes. So I do have that, and I will go through that. But there was another thing, everybody. If we take a peek in here too, at the cases that the Supreme Court's granted cert on, which means they are willing to hear those cases, we have another case in here, and it's the Fisher versus United States case, and they've granted cert on this. Now, this was one of 3 fellas who had appealed their Jan 6 convictions, claiming that the section of the code, the interference with a government function, is unconstitutional the way the prosecutors used it. So they have agreed now to hear the case. So this cert I do want to go through as well at some point, because it is very interesting. This could have huge effects because, of course, if the Supreme Court holds that this application of the statute is unconstitutional, then that would bar the charge against Mr. Trump as well. So lots going on with that. Very interesting argument. I disagree with them, but it's an interesting argument. Can you explain what it means to grant cert? Sure. So, the court's only in session a certain amount of time during the year, and they can only take a certain number of cases. So in order to get your case heard by the U.S. Supreme Court, you draft a petition for a writ of certiorari. So writ of certiorari means that you want the U.S. Supreme Court to hear and decide your case. So we just shorten it to cert. There's lots of different writs out there, which would be commands from the courts. We've got a writ of habeas corpus, which means bring the body before the court, or a writ of mandamus, which is like an order for the court to give to another government body. So a writ of certiorari means it's the mechanism for allowing the Supreme Court to hear a case. So when they grant it, it means they've looked at the question presented in the case and have agreed then to hear arguments. If they deny cert, like they did here, it means the lower court's decision stands. So that's why, we're in retrograde. Okay, well, Kristen, that explains a lot, because it's been madness today, everybody. Complete madness. It's been madness all the way around. So, yes, a very interesting couple of things here. So, I do have and do plan to go through the Mifepristone case. I think those are very important. That's a very important case for us to go through because of the legal questions or the lack of proper legal questions, in my opinion here. But I think it's important. So I will go through that, but just not tonight, everybody. I apologize for that. Just 2 nights in a row is too much. So what I would like to go through, though, is the DC opinion and order by Judge Chutkin first, and then take you through the cert by Mr. Fisher regarding whether or not he was charged constitutionally for his actions in the January 6th insurrection. Okay, so hopefully that'll be okay for everybody. Oh, and the other thing, oh my goodness, no need to apologize. Yes, I think so. I think we all could use a break. The other thing, though, that I did want to ask as well was we did have the United States Court of Appeals for the Second Circuit just issued their opinion on whether or not presidential immunity will apply to Mr. Trump regarding E. Jean Carroll in the defamation suit. Spoiler, no, it doesn't. He can't use it. So I also have this too. So I wasn't sure if the Jan 6th writ was more important, or if you would like to go through the presidential immunity E. Jean Carroll case. So yeah, spoiler alert. Spoiler, nope. So we have a lot. We just have so much going on right now, everybody. Jan 6th. Yeah, that's kind of where I was leaning too. Jan 6th. Okay, absolutely, absolutely. So that was how I was leaning too. I do like to go through and kind of spot check certain words in any of the Carroll cases, and I haven't really been able to go through it as thoroughly as I would like. So I'll probably prep this up to do on the next live then for sure, because I think it's a good opinion, but it's one that requires a little extra caution when presenting it. So, all right then, everybody. So why would he have presidential immunity for E. Jean Carroll? Because some of the statements he made while he was president. Yep. I know. I know. It's a lot. The Trump NFT website. Well, okay. I could put that on my list. Let me add that to my list here. Yeah, we got a lot going on. I thought I saw somewhere that some new digital cards just came out, speaking of that. So, all right, everybody. So let's get started. This is a very short opinion from Judge Chutkan out of the DC case. I'll just start with this quick, and then I will jump into that Jan 6th writ that I think is so important that we go through. So here we go. He is a walking court docket. It's a lot, everybody. It really is. All right, so my day's been so stressful, I had to get out my cow pen. So hopefully that will give us all some comfort. So I've got my cow pen out. Oh my goodness, buckle up. Yep. If you buy 99, you get a piece of the suit. Really? Oh my gosh. Which suit? Like his inauguration suit? Oh my goodness. Oh my goodness. A shredded suit. Oh my gosh. What? That's a lot. The mugshot suit. Oh my gosh. That's something else, everybody. Well, to each their own, and filed a motion to stay proceeding pending appeal. For the reasons set forth below, the court will grant in part and deny in part defendant's motions, which she really does do that quite a lot. Quite a lot. So, the filing of a notice of appeal is an event of jurisdictional significance. It confers jurisdiction on the Court of Appeals and divests the district court of its control over those aspects of the case involved in the appeal. Citing that Griggs case that we spoke about yesterday, the Supreme Court applied the Griggs principle to an interlocutory appeal of the denial of a motion to compel arbitration. So one of the things that I think is significant is to note the difference between arbitration and this type of proceeding. But there we have it, nevertheless, holding that any further proceedings before the district court must automatically be stayed. The court reasoned that because whether the litigation may go forward in the district court is precisely what the Court of Appeals must decide. It makes no sense for trial to go forward while the Court of Appeals cogitates. That's really unnecessary, Judge Chutkan. Seriously, cogitates, come on whether there should be one. Oh, it's a direct quote. Okay, you're forgiven now. Oh my goodness. And the court analogizes its holding to similar decisions in the context of appeals involving immunity and double jeopardy. Okay. Oh my gosh. All right. So page 2, again, Judge Chutkan's order just came out today for DC. As the DC Circuit recently made clear, a former president's absolute immunity would constitute an entitlement not to stand trial or face other burdens of litigation, such as discovery obligations. And she's citing the Blessing Game case, which I did do on a live before. Thus, because defendant has appealed this court's denial of that immunity, whether the litigation may go forward in the district court is precisely what the Court of Appeals must decide, citing the Coinbase case. Consequently, the court agrees with both parties that defendant's appeal automatically stays any further proceeding that would move this case towards trial or impose additional burdens of litigation on the defendant. All right, so she's definitely putting out and saying, she's putting it out there. She's believing that we need to pause the proceedings here. Accordingly, and for clarity, the court hereby stays the deadlines in proceedings scheduled by its pretrial order as amended. So let's take a look and see what's been paused. The court emphasizes two limits on that stay. First, as defendant notes, the stayed deadlines in proceedings are held in abeyance, motion at 1, rather than permanently vacated. So she's just pausing them while this is on appeal. If jurisdiction is returned to this court, it will, consistent with its duty to ensure both a speedy trial and fairness for all parties, consider at that time whether to retain or continue the dates of any still future deadlines and proceedings, including the trial scheduled for March 4th. So she's keeping the trial scheduled for the same date, keeping deadlines still going so that when she gets the case back, they will just pick up where they left off. As best as they can. Second, as long as it's appropriate. Second, the court does not understand the required stay of further proceedings to divest it of jurisdiction to enforce the measures it already imposed to safeguard the integrity of these proceedings, including defendant's conditions of release, so that's important, the protective orders governing discovery materials, also very important. The restrictions on extrajudicial statements. So this is that kind of gag order that we talked about before. She's saying she can still enforce that. That's still in place as modified by the D.C. Circuit's decision in U.S. v. Trump. So there were really the only change was that he could call Jack out as much as he wanted to. And protective jury procedures, which had already been determined as well. All right, so everything will remain in place as we wait. Unlike, for example, requiring additional discovery or briefing, maintaining those measures does not advance the case towards trial or impose burdens of litigation on defendant beyond those he already carries. And if a criminal defendant could bypass those critical safeguards merely by asserting immunity, then appealing its denial, then during the appeal's pendency, the defendant could irreparably harm any future proceedings and their participants. That said, there's little precedent guiding the application of Griggs to such a protective measures. The Ninth Circuit, at least, has transferred a motion to enforce a protective order back to the district court, even though the circuit had taken jurisdiction over the merits of the decision below, including the judgment, reasoning that the district court has not been divested of its jurisdiction over ancillary matters, such as protective orders, citing case law here. But the parties have not identified, and the court is not aware of any guiding precedent in this circuit on that issue, much less instructive cases in the context of an interlocutory immunity appeal. In addition, defendant does not appear to argue that the protective measures are themselves stayed. Nonetheless, if he asks the court reviewing his immunity appeal to also take temporary jurisdiction over the enforcement of those measures, and that court agrees to do so, this court will, of course, will be bound by that decision. Signed, Judge Chutkin. So, there we have it, everybody. We are officially paused for the DC case. All right. The dates, everything will remain the same once it comes back to her after it goes to appeal. So who typed this up? Well, that's a good question. I have no idea. But here we go. I think I can't say whether I agree or disagree. I think this is just absolutely within her prerogative, her ability to do this, and it seems like in almost everything she's splitting everything. So it looks like she's split again. She's saying, hey, we're going to go ahead and pause everything, but I'm still going to watch out for that protective order. We're still going to have the jury protections in place, discovery protections in place, and we'll pick it up where we left off when it comes back. So she's really kind of, splitting the situation again. I'm not sure she's a Trump supporter. I think she just likes to be extremely safe. I think she likes to err on the side of being very safe. She's very cautious. Too, and if you think about it, her original gag order, if you remember, she had put it into place, and then she herself had stayed that gag order until further briefing could be done, and then had reinstituted it. So I think she's just extremely careful and cautious in how she's doing it. How long? It'll depend on when that Court of Appeals decides it. Sounds like that is being expedited. So it shouldn't be too long then. I think everybody knows how important time is here. So I think they'll be pretty careful. When can we expect the appeal to be ruled on? Well, it's on the fast track. So at this point, I'm not completely sure, but I would say I wouldn't be surprised if we heard within the next couple of weeks or that very first week in January. Yes, why isn't he going to jail? Well, I mean, you know, we got to have a trial. You got to be found guilty first, and then we got to figure out if jail's the best option. It takes a while. It takes a while, everybody. You know, and again, too, to figure out what the proper accountability is. So it does take a while. It's filing is due December 20th. Okay, thanks, Jim. Thanks. They just haven't yes. So, you know, it'll take a little time. I'm not surprised the judge came out this way. I would disagree about it, but I'm not the judge. I mean, there's a reason I'm not sitting in that position. So she's doing the best she can with what she has to work with. So why all the delays? Well, that's just part of the process. This case has already been going a lot quicker than many cases. So I think, you know, we can expect to have a lot of this like hurry up and wait occurring. What's next to read? So, yes, Cannon paused her case too in Florida. Now, Suze, I've not seen any new orders yet. I've been watching that docket. I've not seen anything new at this point. So I do want to do an update on Florida very soon. But I just haven't seen what she's gotten. But she did pause a few things and pushed a few things further down the road at this point. Longer you delay. Yes, it's true. And that's definitely one of the textbook strategies. You saw it on X, really? Okay, interesting. Yeah, I mean, she's still scheduled for May, right? But if this case gets pushed further past that March deadline into April, you know, she may push her case as well. So a lot of things are kind of, you know, we're kind of in a waiting pattern right now. But yeah, that is absolutely a legal strategy, is to delay things as far as you possibly can. It takes a while when you have money. That's an excellent way of putting that. Very accurate. All right, everybody. So that's what I've got here out of the DC case. So that was the update there. But for tonight, the big document I wanted to go through then. Better have him exhaust as many reasons to delay early on. I agree. Yes, that's what I saw too, VC. So I do have for tonight... again, just to remind everybody, we did have the SCOTUS, or the U.S. Supreme Court, granted cert for multiple cases today. The big one, of course, was the FDA versus Alliance Hippocratic Medicine case, and that's a combination of 3 cases. 2 cert was granted, 1 cert was denied. But then we also have Fisher versus United States, where we have a Jan 6th person who had been convicted, and he had appealed, claiming he was charged unconstitutionally. This, of course, would have some pretty significant effects on Mr. Trump's DC case. So if you'll give me just a moment, I will go ahead and turn comments off so that I can read through the document. Oh, and I have to go grab my new kitten, who is now getting into one of my cups of tea. So just a moment. Okay, come on. Come on, kitty. Come on. Come on. Okay, so... Thank you, VC. I bet you turned those comments off for me. Thank you kindly, ma'am. I appreciate that. So, welcome everybody. This will be our big document reading for tonight. I will be going through this petition for a writ of certiorari. This cert was granted today by the U.S. Supreme Court. It's actually not very long. It kind of looks long, but writ of certs aren't actually that long. So I will read through this and then do a Q&A afterwards and kind of talk through what some of these issues are. Now, Mr. Fisher is one of 3 men who was convicted under a particular section of the United States Code of interfering with a government function, which is also what Mr. Trump's been charged with in the DC case. He is claiming that that section of the code, the way that it had been used on his indictment, was unconstitutional. So he has appealed to the U.S. Supreme Court. So here we go, everybody. All right, let me get my sticky notes out just so everyone knows what I'm talking about. All right. So this is Fisher v. U.S., and this is a petition for cert, and this is on the Jan 6th case. Probably not the best description, but it's the best I've got for tonight. All right, everyone, here we go. So first we have question presented, which is part of the requirements when you set out a petition for a writ of cert. So, did the D.C. Circuit err in construing 18 U.S. Code, Section 1512 sub C, witness, victim, or informant tampering, which prohibits obstruction of congressional inquiries and investigations to include acts unrelated to investigations and evidence? Very interesting question here. Now, they will go into the legislative history. A lot of this came about because of a concern for documents. And so the question is, we don't really have a document situation going on, so is it really applicable? So let's get into it. All right, we have the parties to the proceedings here, and United States is the respondent. Petitioners, Mr. Fisher. Related parties here. So here are some of the other fellas who were also charged under the same code section. So we have Mr. Miller and Mr. Lang. Here we do have a writ that was filed by Mr. Lang, but again, that was not taken up yet. So we have next the table of contents. Question presented. They're talking about the parties, related parties, table of authorities, the petition itself, opinions, jurisdiction, constitutional provisions, statutory provision, the introduction, then statement of the case. They do go into the factual background, the charges in the district court's decision on the scope of Section 1512C2 of the U.S. Code, the appeal, so we have the lead opinion included, the conditional concurrence, the dissenting opinion, which plays an interesting role, and the mandate. Last, we have reasons for granting the petition, and they set out a couple of arguments here, and then have a conclusion in place. So it's really not that long of a petition. So we'll just kind of dive right in, everybody. So here's our table of authorities that they are listing out at the very beginning here. And they will be referencing the other fellows that were charged as well as we go through it. We have the statute sections here that they're referencing, other authorities. So we do have a few other sources that they're using, like a couple of memorandums here, an article written by Scalia and Garner set out as well. So next we've got the petition statement here. So they're petitioning the court for writ of cert, so they're wanting their issue to be heard. We have opinions below. So the District of Columbia Circuit is reported in the U.S. v. Fisher case that was below. They did add it to the appendix here. That's why it looks like there's so many pages. Next, we have jurisdiction as well. So let's get into the case. We do have the constitutional provisions, which they do explain further, as well as the statutory provisions. So here's the introduction. All right. Let me make sure I'm in frame. I'm trying to place this so it doesn't have a, there we go. Okay, the D.C. Circuit's interpretation of the anti-shredding provisions of the Corporate Fraud and Accountability Act of 2002, 18 U.S. Code Section 1512C2 presents an important question of federal law affecting hundreds of prosecutions arising from January 6th, including the prosecution of former President Donald Trump. See indictment here. The D.C. Circuit's opinion conflicts with this court's precedent, diverges from the construction of Section 1512C by the other courts of appeals, and results, as Judge Katsas observed, in an implausibly broad provision that's unconstitutional in many applications. So there's an anti-shredding provision that people are being charged under, is how they're categorizing it. So that theme will be continued on as we go through this. Very interesting argument they have here. Statement of the case. Factual background. Spurred by President Trump's urging, petitioner, Mr. Fisher, and a companion attended the Stop the Steal rally on January 6th at the Ellipse. Unlike many of the other attendees, Mr. Fisher did not subsequently march with the crowd to the Capitol. Instead, he and his companion headed home. But after learning of the swelling demonstration, Mr. Fisher and his companion drove back to Washington, D.C. Just make sure I'm in frame. Mr. Fisher was not part of the mob that forced the electoral certification to stop. He arrived at the Capitol grounds well after Congress recessed. And as Mr. Fisher walked towards the east side of the building, no barricades or fences impeded him. He ultimately entered the Capitol around 3:25 p.m. Police video captures Mr. Fisher's conduct inside the building. It reveals, for example, that he pushed his way through the crowd to about 20 feet inside the building. But as he neared the police line, the swell of the crowd then knocked Mr. Fisher to the ground. Returning to his feet, Mr. Fisher returned lost equipment, a pair of handcuffs, to a Capitol police officer. He talked with an officer, patting him on the shoulder. Then the weight of the crowd pushed Mr. Fisher into the police line. With that, the Capitol Police pepper sprayed the protesters, blinding Mr. Fisher. He exited 4 minutes after entering. I do want to flip back and get that footnote, everybody, on the previous page real quick. So we do have our first footnote here, which is citing again to the original petition. The lead opinion ultimately acknowledges this fact. So they are acknowledging the fact that Congress had recessed by the time he had gone back. So that is an important part for his argument. The charges in the district court's decision on the scope of Section 1512C2. A grand jury returned a 7-count indictment. The indictment charged Mr. Fisher with several specific offenses. Civil disorder under 231A3, Count 1, assaulting, resisting, or impeding certain officers, Section 111A1, and Count 2, entering and remaining in a restricted building or grounds, 1752 for Count 3, Count 4, disorderly conduct in a restricted building, 1752A2, Count 5, disorderly conduct in a Capitol building, 5104E2D, Count 6, and parading, demonstrating, or picketing in a Capitol building, 5104E3G, Count 7. However, as in so many other cases like Mr. Fisher's, the government also charged a violation of Section 1512, Count 3, which prohibits evidence impairment in connection with, among other things, a proceeding before the Congress. Judge Nichols granted Mr. Fisher's motion to dismiss the Section 1512C count based on his opinion in U.S. v. Miller. In Miller, Judge Nichols construed Section 1512C based on its language, structure, history, and relevant interpretive canons. At the outset, he emphasized that the court must exercise restraint in assessing the reach of a criminal statute. Citing Miller. As for the reach of Section 1512C, Judge Nichols began by pointing out that 3 readings of the statute are possible, but only 2 are plausible. Again, that is the same code section that Mr. Trump has been charged with. Take just a quick tea break, everybody, for just a moment. The first advanced by the government was at subsection C2, which begins with the term otherwise, and then states obstructs, influences, or impedes any official proceeding or attempts to do so, constitutes a clean break from subsection C1, setting forth an omnibus clause independent of the preceding subsection. But Judge Nichols identified several problems with the government's interpretation. One, it ignored that otherwise has several different definitions that imply a relationship with something else. Okay? Two, it failed to give meaning to the term otherwise, rendering it surplusage. Three, the government's interpretation conflicted with how this court has construed otherwise in Begay v. U.S., abrogated on other grounds by Johnson v. U.S., 2015, which addressed a different statute but similar framework. While acknowledging that other courts had interpreted subsection C2 consistent with the government's position, Judge Nichols viewed this authority as conflicting with this court's reasoning. Next, he addressed whether subsection C1 merely provides examples of conduct that violates subsection C2. Judge Nichols acknowledged that this construction gave effect to the term otherwise by tethering the subsections through a common link to an official proceeding, but he found that this construction had its own problems. For example, if the common element is an official proceeding, then otherwise is superfluous, and both subsections reference official proceedings. Judge Nichols explained that the structure of section 1512C cut against the construing subsection C1 as merely including examples of conduct violating C2. In his view, a reasonable reader would not expect the principal-only offense to be in the second subsection. Finally, Judge Nichols considered whether subsection C2 constituted a residual clause for C1. Under this construction, the word otherwise links the two subsections with the commonality being the conduct prescribed in C1. And it squared with this court's reasoning in the holding in Begay. But, for instance, subsection C2 ensures that by criminalizing specific acts in C1 that impair evidence, Congress was not under-inclusive in proscribing interference with the availability and integrity of all types of evidence. Turning to statutory context, Judge Nichols viewed it as supporting a narrow focus in subsection C2. For instance, he noted that Congress aimed section 1512's other subsections at discrete conduct in narrow circumstances, like killing a person to prevent their attendance at an official proceeding. And the title of the section further suggests a narrow evidentiary focus. Absent such focus, Judge Nichols emphasized that a broad reading would cause substantial substantial problems. In other words, the majority of section 1512 would be unnecessary. Looking next to the statutory history, Judge Nichols found that it too reinforced construing subsection C2 as limited to the types of actions described in C1. At this point, he traced the development of section 1512C and observed that it filled a gap, that is, not requiring that the obstructor act through another person. Last, Judge Nichols recounted the history surrounding 1512C's enactment as part of the Sarbanes-Oxley Act of 2002, emphasizing Congress's focus on deterring fraud and abuse by corporate executives. Section 1512C followed the notorious cases of Enron and Arthur Andersen, LLP, where documents were shredded to stymie an investigation. In other words, federal authorities could prosecute individuals under Section 1512C when they acted alone or before the existence of a proceeding in a subpoena. Subsection C, the appeal. Number 1, the lead opinion. Judge Pan conceded that there is no precedent for applying Section 1512C to conduct unrelated to evidence impairment, and that such application was beyond Congress's expressed purpose in amending that section. Yet Judge Pan viewed the terms in Section 15C2 describing the actus reus to be clear, unambiguous, and supporting a broad reading. And absent a grievous ambiguity, Judge Pan did not believe the rule of lenity had any role to play. As to the government's argument that the mens rea of corruptly limited the statutory reach, Judge Pan demurred. Because the assault allegations, in her view, satisfied any mens rea standard, Judge Pan did not reach the issue, and she offered that the definition adopted in Judge Walker's concurrence should, for the same reasons, await briefing in a different case. Finally, Judge Pan emphasized that the concurring opinion warranted no precedential effect. Number 2, the conditional concurrence. Judge Walker concurred because the lead opinion's rationale was not enough to uphold the indictments in the absence of a definition of the mens rea element. Mens rea means intent. Judge Walker repeatedly characterized the government's construction of Section 1512C2's act and mental state as breathtaking in scope, subjecting it to vagueness and overbreadth concerns. Judge Walker reasoned that the most efficient way to narrow the lead opinion's construction was through the mens rea element corruptly. Judge Walker defined corruptly as requiring proof that the defendant not only knew he was obtaining an unlawful benefit, but that his objective or purpose was to obtain that unlawful benefit. Judge Walker explained that narrowing the mens rea makes sense of subsection C2's placement within the statutory scheme. Finally, Judge Walker emphasized the conditional nature of his concurrence. Though the district court did not reach the meaning of corruptly, we have no choice. My vote is to uphold the indictments. Depend on it. If I did not read corruptly narrowly, I would join the dissenting opinion. Giving corruptly its narrow, long-established meaning resolves otherwise compelling structural arguments for affirming the district court, as well as the defendant's vagueness concerns. Part 3, the dissenting opinion. Judge Katsas concluded that both the government and the lead opinion dubiously read the term otherwise in Section 1512C2 to mean in a different manner, as opposed to in a manner like the list in subsection C1. Such reading, Judge Katsas explained, rendered subsection C1 ineffective, and it made Section 1512C implausibly broad and unconstitutional in many applications. Instead, Judge Katsas relied on the normal linguistic usage that the verbs preceding otherwise help frame and narrow its meaning. This usage adheres to the textualism's goal, that is, not to explore definitional possibilities, but to assess how an ordinary person would understand the phrase Congress strung together. Make sure I'm in frame here. Judge Katsas also explained that the canons of statutory instruction include avoiding surplusage by giving effect to every clause and word. Another canon, ejusdem generis, cautions that when general words follow specific ones, the general words are construed as embracing only objects like those enumerated. Similarly, the canon of nocitur et socis provides that a word is given precise content by the neighboring words with which it is associated. Here, otherwise takes meaning from the specific examples preceding it. As Judge Katsas recognized, the expansive interpretation advanced by the government and adopted in the lead opinion would swallow up various other Chapter 73 offenses outside of Section 1512. Judge Katsas next noted that the statutory history surrounding Section 1512 and its application in the courts went against the lead opinion's unprecedented expansion of its reach. Given the ambiguity surrounding the statutory reach and the unconstitutional breadth, Judge Katsas believed that the rule of lenity applied. Finally, as for the approach suggested in the concurrence, Judge Katsas lauded the goal of narrowing the government and lead opinion's breathtaking and untenable construction of the statute. But in Judge Katsas's view, the heightened mens rea requirement that the concurrence proposed would not alter the improbable breadth of the actus reus. In other words, Judge Katsas viewed the unlawful benefit mens rea definition as necessary but not efficient. The mandate. In the wake of these opinions, Mr. Fisher and Miller moved to stay the mandate so they could seek review in this court. The panel granted that request. And this court being, of course, the U.S. Supreme Court. So, next, reasons for granting the petition. Thank you very much. Sub A, the D.C. Circuit's lead opinion construed Section 1512C2's actus reus in a manner that directly conflicts with this court's statutory construction precedent. The court has held that when there are two plausible readings of a statute's scope, one limited and one near limitless, precedent and prudence require a careful examination of the statute's text and structure. Citing case law here. This precept dovetails with the principle of exercising restraint in assessing the reach of a federal criminal statute. Citing case law, restraint arises out of a deference for Congress and concern for fair warning of what the law proscribes. And then we have our second footnote here, everybody. Footnote 2. Crime should be defined by the legislature, not by clever prosecutors riffing on equivocal language. Correspondingly, the Due Process Clause bars courts from retroactively applying novel judicial constructions to conduct that neither the statute nor any prior judicial decision has fairly disclosed to be within its scope. Citing the linear case. Here, there's more than one plausible reading of Section 1512C2. 4 judges have reviewed subsection C2, and they arrived at 3 plausible readings. The district court viewed C2 as limited by C1, thus requiring some action over a document, a record, or other object. But in the D.C. Circuit's lead opinion, Judge Pan viewed C2 as independent of C1 and encompassing all forms of obstructive acts, even while conceding that her reading of C2 criminalizes acts well beyond those anticipated. By Congress, and then we have our next footnote 3 here. On this characterization of Section 1512C2, the panel agreed. Oh, thank you so much, John. I appreciate that. Back up we go. And though Judge Walker agreed in the conditional concurrence that C2 had a breathtaking scope, he opted to rein it in through a stricter interpretation of the mens rea acting corruptly. Finally, in dissent, Judge Katsas viewed C2 as embracing more than physical evidence, documents, and records, and he would limit its range to acts of evidence impairment. The D.C. Circuit's lead opinion cannot be squared with Dublin and its supporting precedent. And then we have footnote 4, citing more case law down here. To avoid this precedent, the lead opinion declared that the term otherwise in subsection C2 was clear and unambiguous. And then footnote 5, the lead opinion also addressed the rule of lenity, characterizing it as only applying when a statute contains a grievous ambiguity or uncertainty. But it's far from clear that ambiguity must meet some sort of threshold standard of grievousness before the rule of lenity applies. Citing case law by Gorsuch and Sotomayor, concurring, tracking the history of using grievous when describing an ambiguity, citing case law again, with Scalia dissenting, Contrary to the majority's miserly, grievous ambiguity approach, the rule of lenity applies whenever, after all legitimate tools of interpretation have been exhausted, a reasonable doubt persists regarding whether Congress has made the defendant's conduct a federal crime. Resolution of the standard for applying the rule of lenity thus provides another basis for this court's review. But that declaration, too, conflicts with the precedent from this court for at least 6 reasons. First, by reading the term otherwise in isolation and thereby according it an expansive definition, the lead opinion violated this court's whole text canon. Then we are citing case law. In other words, courts must not divorce words from their statutory context, which provides the primary determinant of meaning. The canon has particular import when, as here, the term at issue is capable of more than one meaning and introduces a residual clause. Second, this court has routinely employed the whole text canon against surplusage. Citing the Yates case, which was a plurality opinion, put differently, the interpretation of a statute is directed towards giving effect to every word. The D.C. Circuit's lead opinion acknowledged this precedent, but discounted it by stating that superfluity is not by itself enough to require a particular interpretation. While that's true, it ignores the other part of this court's surplusage precedents. That is, the surplusage canon is strongest when an interpretation would render superfluous another part of the same statutory scheme. Citing case law here. Here, the lead opinion's interpretation collapses wholesale parts of Section 1512, 15 offenses, into subsection C2. And then we have footnote 6. The location of this omnibus offense in the middle of a statute and in a subsection of a subsection flouts another of this court's canons of construction. Congress does not hide elephants in mouse holes. All right, that's interesting. That sounds like something Judge Ingeron would say. And the lead opinion's interpretation absorbs other Chapter 73 offenses outside Section 1512, including Sections 1503 and 1505. The scope of the superfluity alone warrants this court's review. Third, this court has used, let me make sure I'm in frame, everybody, the canon of adjustus generis to construe general words like otherwise when they follow specific words. This rule prevents the general words from rendering the specific ones meaningless. The lead opinion's interpretation of subsection C2 renders C1 meaningless. Again, the lead opinion sidesteps this court's precedent by treating the rule as inapplicable unless the list of terms directly preceded the general term. Yet, here they are all part of one sentence. Fourth, this court has regularly applied the associated words canon nociter a associes to determine statutory scope. This rule focuses on the neighboring words to establish the contours of a general term. Citing MacDonald, as with the preceding canon, the legal opinion dismissed it based on the view that the associated words were too far away, but they are in the same sentence. All right, I'm seeing a repetition here. That's an excellent strategy when writing. Fifth, this court has construed other sections of the Sarbanes-Oxley Act to prevent similarly unrestrained readings of its proscriptions. In Yates, this court's addressed the scope of 18 U.S. Code 1519. Section 1519 authorizes a prison term of up to 20 years for anyone who knowingly alters, destroys, mutilates, conceals, covers up, falsifies, or makes a false entry in any record, document, or tangible object with the intent to impede, obstruct, or influence the investigation of a proper administration of any matter within the jurisdiction of any department or agency of the United States. The question presented was whether a fish counted as a tangible object under Section 1519. Okay. writing for the plurality, Justice Ginsburg acknowledged that although a fish is no doubt an object that's tangible, it would cut Section 1519 loose from its financial fraud mooring to hold that it encompasses any and all objects, whatever their size or significance, destroyed with obstructive intent. Mindful that in Sarbanes-Oxley, Congress trained its attention on corporate and accounting deception and cover-ups, the plurality therefore concluded that a tangible object captured by Section 1519 must be one used to record or preserve information and does not include fish. Okay. Oh my gosh. In so holding, the plurality rejected the government's unrestrained reading of Section 1519 as a general ban on the spoliation of evidence, covering all physical items that might be relevant to any matter under federal investigation. This court's intervention is required to correct the D.C. Circuit's unrestrained reading of Section 1512C, which divorces Section 1512C from its statutory context as an evidence impairment crime. Sixth and finally, this court and other courts of appeal have employed the above framework when interpreting analogous residual clauses. For example, in Begay, this court considered the scope of the residual clause in the Armed Career Criminal Act. The question in Begay was whether a driving under the influence, a DUI offense, constituted a crime. That under Section 924E2B2 otherwise involves conduct that presents a serious potential risk of physical injury to another. This court determined that the proximity of the listed crimes, burglary, arson, extortion, or crimes involving the use of explosives to a general crime, otherwise involving conduct that presents a serious potential risk of physical injury to another, was enough to indicate that the otherwise clause covers only similar crimes rather than every crime that presents a serious potential risk of physical injury to another. As this court explained, if Congress meant the statute to be all-encompassing, it's hard to see why it would have needed to include the examples at all. And the courts of appeal have followed suit. And we're citing case law here, construing otherwise in the sentencing guidelines as relating to examples in the preceding subsection. So subsection B, the other courts of appeal have interpreted Section 1512C2 consistent with the statute's historical roots and legislative purpose. At least two federal courts of appeal have limited Section 1512C2 to instances of corporate document shredding to hide evidence of financial wrongdoing. And we're citing case law here. First with Yates and Sutherland prosecuting based off of false loan documents, then the Gordon case, backdating agreement purporting to memorialize a sale of stock that never took place. And this is how the district court viewed Section 1512C2 in Mr. Fisher's case. Now, we do have footnote 7 here. Let me just pull that one out. It's at the very end down here. Correspondingly, the historical definition of an official proceeding derives from Section 1503 and 1505 as involving investigations and evidence. So that's for clarification. Oh, I will just pause for a quick tea break. Just one moment. Four other federal courts have given a more expansive scope to Section 1512C2, but they have uniformly limited the statute's reach to crimes of evidence impairment, making false statements directly to the grand jury itself sufficient to satisfy Section 1512C2. Citing the Burge case, false responses to interrogations that were filed in official proceedings sufficient to satisfy 1512C2. Volpendesto soliciting information from corrupt cops in order to evade surveillance constituted evidence sufficient for a jury to find efforts were out of desire to influence what evidence came before the grand jury. And then we're citing Petrick, seeking to obtain false statements to be used in pending federal charges sufficient to satisfy Section 1512C2, and Phillips disclosing identity of undercover agent to subject of grand jury drug investigation evidence sufficient to find purpose was to thwart evidence from reaching the investigation. Then we have footnote 8. The district court criticizes the 7th and 8th Circuit opinions in Burge and Petrick for basing their holdings on a misreading of the court's opinion in Aguilar. The district court then noted that the 7th Circuit's later decision in Volpendesto did not involve a prosecution under Section 1512C2. The D.C. Circuit's lead opinion, however, relies on Petrick, Burge, and Volpendesto without acknowledging the district court's criticism. Ooh, good catch. The D.C. Court's expansion of Section 1512C2 beyond evidence impairment to protests at the seat of government thus conflicts with the interpretations of other courts of appeal limiting the scope of the same statute. Then we have footnote 9. Until January 6th prosecutions, the government similarly viewed Section 1512C as confined to acts of evidence impairment. See generally memorandum from Deputy Attorney General Rod Rosenstein and Assistant Attorney General Stephen Engel to Attorney General William P. Barr at 2, asserting that Section 1512C2 is confined to acts of evidence impairment. Memorandum from Assistant Attorney General Office of Legal Counsel Stephen Engel and Principal Associate Deputy Attorney General Edward O. Callahan to Attorney General William Barr, emphasizing that potentially obstructive conduct did not involve efforts to impair or alter documentary or physical evidence. That's interesting. Okay, back up to subsection C. Section 1512C2 scope remains unclear because neither of the D.C. Circuit nor the district courts have agreed on a definition of corruptly, its mens rea element, thus further exacerbating the vagueness and overbreadth of concerns. While some courts have limited Section 1512C2 scope by a particular definition of critical mens rea element, corruptly, they have not defined it uniformly. Citing case law here, and the D.C. Circuit's lead opinion declined to define it at all, even while stating that corrupt intent limited Section 1512C2's reach. Citing the petitions set out here, the lead opinion nonetheless acknowledged 3 potential definitions. First, corruptly means conduct that is wrongful, immoral, depraved, or evil, citing the Arthur Anderson case. 2, undertaken with a corrupt purpose or through independently corrupt means or both, citing Sandlin and North. And 3, conduct that involves voluntary and intentionally acting to bring about either an unlawful result or a lawful result by some unlawful method. That's a tongue twister, everybody. Let me go back again. Conduct that involves voluntary and intentionally acting to bring about either an unlawful result or a lawful result by some unlawful method with a hope or expectation of either financial gain or other benefit to oneself or benefit to another person. And then this is quoting the Aguilar case. In contrast to the lead opinion, Judge Walker addressed the meaning of corruptly, defining it narrowly to avoid rendering Section 1512C2 a vague and far-reaching criminal provision. Consistent with Justice Thomas and Justice Alito's dissent in Marinello, Judge Walker defined corruptly as requiring proof that the defendant not only knew he was obtaining an unlawful benefit, but that his objective or purpose was to obtain that unlawful benefit. Interesting. Thomas Alito dissenting, internal quotations omitted. Judge Walker concurred on the condition that Judge Pan accepted his definition, although she declined to do so. My reading of corruptly is necessary to my vote to join the lead opinion's proposed holding on obstructs, influences, and impedes an official proceeding. If I did not read corruptly narrowly, I would join the dissenting opinion. Judge Katsas stated that a narrower definition of corruptly was insufficient by itself to narrow the broad actus rea. In any event, Judge Katsas declined to endorse the mens rea definition proposed in Judge Walker's conditional concurrence, observing that it relied for the most part on dissenting opinions. The D.C. Circuit panel's internal disagreements over which mens rea definition properly limits Section 1512C2's reach is yet another reason for this course review. Subsection D. Here's our final subsection, everybody. The scope of Section 1512C2 is a recurrent question, and this case presents an ideal vehicle for resolving it. Hundreds of cases have been and will be affected by the scope of Section 1512C2, including a case against the former president, citing the Capitol breach cases. In addition, the use of Section 1512C2 outside evidence impairment crimes is an extraordinary and unprecedented extension of the statute's reach. Judge Katsas questioned a construction of subsection C2 that would reach the kinds of advocacy, lobbying, and protests that citizens often employ to influence official proceedings. These concerns are not speculative. Already, the broad scope of the D.C. Circuit's interpretation has yielded calls for its use in other contexts. Senator Cotton has begun probing why Justice Department officials have not yet launched criminal investigations under Section 1512C2 for those protesting gun violence at the Tennessee Capitol and those protesting Representative Jordan's House Judiciary Committee hearing in New York City. And then we're citing various sources there. Indeed, Senator Cotton refers to the lead opinion in Fisher during his questioning. Mr. Fisher's case is an ideal vehicle for resolving the issue presented. His petition in particular is in the optimal procedural posture as he has not been tried, and the mandate in his case has been stayed pending the filing of this petition. Accordingly, a decision from this court will allow his trial to go forward with the legal questions resolved, and thus in the most efficient way possible. In addition, the interpretation of Section 1512C and its reach are questions of law and thus subject to de novo review. There's no extensive record here, nor any disputed facts concerning what happened on the 3-minute, 49-second video captured in the Capitol. The D.C. Circuit passed upon all the legal arguments at issue in the case, and thus there are no questions of preservation that might otherwise create difficulties. With hundreds of cases awaiting trial and others on direct review, this court's clarification of the scope of Section 1512 and the required mental state for a violation of the statute would provide critical guidance to the district courts, prosecutors, and defense counsel. Conclusion: for all these reasons, this honorable court should grant the petition for writ of certiorari. So that was filed. Requesting a cert from the U.S. Supreme Court. So let me go ahead and turn comments back on. We can talk about that for a little bit here. Hello, everybody. Welcome back again. That was interesting. What do we think about that? Very interesting. Yes. Your legs are in frame just a little. No feet. No. No, that can't be. That can't be. Oh my gosh. Can we see clause 1 and clause 2? Oh, C1 and C2? Sure. Oh, wait, hold on now. We got to get this sorted out. Are my feet in frame? Oh, my gosh. You know how I feel about that. What do I think will happen? I don't know, everybody. I think it's an interesting argument. So here is... Here it is, everybody. So this is the code section we're talking about, 1512C2. So, tampering with a witness, victim, or an informant. C, whoever corruptly, otherwise obstructs, influences, or impedes any official proceeding or attempts to do so. So you can see how broad this language is. So we have multiple interpretations. So what they're saying here is they have 3 different views on what this section actually means. One of them is fine, then everything would go forward as is. But if they are either of the other 2, there could be a constitutional issue in how they've been charged. So what they're saying here is that you have some kind of a record, because if you look at subsection 1, alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or otherwise obstructs, influences, or impedes any official proceeding. So you can see what they're saying. One is, if you rely on number 1 as messing with documents, and then if you put into number 2, or otherwise obstructs a proceeding, but not within the context of documents, then that's an appropriate charge for the people who went into the Capitol on January 6th. But if we are only talking about documents, so up here, they're talking about a record, a document, or other object. Here they're saying, or otherwise obstructs that record, document, or other object. So the people who entered the building and caused the disturbance shouldn't be charged under this code section. Yes. Bringing up an X. Yeah. I'll brief in DC Circuit. Calling the Grinch rule. The narrowest reading is used if all other rules fail. Pretty much. But again, it depends on your circuit too. And it sounds like in their circuit, the interpretation of that's even varied a little bit. What about the 2,000 FBI agents? What, that were charged? No, they weren't charged. What are you talking about? You mean obstructing the agents? What? Aren't the electoral votes a document? Yes. So, right. So here's the deal. They're saying there are multiple ways of looking at this. The way that the lower court looked at it had everybody proceeding. But if you look at it a different way, it may need to have the cases tossed. But if you think about it, what was the obstruction? The obstruction was the president of the Senate in his capacity turning over or passing those electoral certificates, right, in order to be counted. So could this not be a way of obstructing those documents from going forward, right? Right? So, I mean, it's interesting, isn't it? It's very interesting. FBI on January 6th. Oh, okay, yeah, no, it wasn't. Nope. Sorry. Do your research. Yep. So this is interesting because there are a couple of different ways to look at it. It doesn't make sense. Well, it seems like it. What they're doing, they're looking at the legislative history, and they're saying the reason why this was put into place to begin with was so that people couldn't destroy documents if Congress wanted them in order to do an investigation. So, during Enron and all of those things, people were shredding documents and, tossing them out the windows. So they're saying that was the history or the intent behind this piece of the law. It wasn't so that people would be prohibited from, literally stopping a document from moving on. Who replies to this for the government? It's not Jack. No, it's not Jack. Whoever the prosecutor is, or whoever their appellate prosecutor would be in this case, would be whoever the counsel is. I'm not sure exactly who that person is, but no, it wouldn't be Jack. Whoever brought the case against Mr. Fisher in D.C. I shredded a lot of paper. Yeah, exactly. But they're saying this section only applies to documents and records. And I'm not sure that that's really, the appropriate definition. So, I think there could be a couple of different ways of looking at it. So they're asking the court to clarify it. Which way the court will go, now that I couldn't tell you. That I could not tell you. They knew what they went there to do and not... Well, I mean, it was an official proceeding, though. It was an official proceeding involving documents. But the other thing, too, is, everybody, you got to keep in mind that that was just one of a ton of other crimes, of other charges that were done. So there was, being in the building without permission. There was all kinds of other charges. Even this person had 7 counts total. Only one of them involved 1512. The reason why this is such a big deal is because Trump's been charged with 1512. But keep in mind, he's been charged with 4 counts. So he has a full 4 counts in there. So again, whether or not this particular code section is the appropriate one to charge, I think is good to kind of get sorted ahead of time too. But the case will still continue to move on. It'll keep going forward. Yep, Jack Smith. I think it's all clarification. Okay. I don't see how C2 applies only to documents. Otherwise, it's pretty straightforward. That's the big question, Fountain. I mean, that's the big question. One of the judges said, well, you have to look at C1 in order to figure out what they mean for C2. Another judge said that's not. If you look at just what this word obstruct means in the common vernacular, and you should go with that definition of what exactly it means to obstruct. And it's not dependent on one. It's its own person. It's its own character. Right. Jack Smith is special counsel. But Trump was intent to obstruct the electoral process. True. Now, I mean, this again is the code section he was charged under. Again, there are 4 sections he was charged under. So here, again, subsection C2, otherwise obstructing, influence, or impeding any official proceeding or attempting to do so. So he was charged with attempting as well as that. So he actually has 2 charges under this code section. So that's it. So this guy, they're saying he just went in and was just in there for a few minutes, didn't have anything to do with it. And even if he did, it has to do with documents. It doesn't have to do with actual people going in there and doing it. But what Trump did, he didn't even go in. He wasn't even going into the Capitol. He wasn't even there. He was talking. He was kind of, getting the crowd all ready to go. So his actions are even more different than this particular defendant's because he was speaking and encouraging people. So that, again, is a different set of acts. So that actus reus comes in as well. And that's what they're talking about with the actus reus, actus rea, and mens rea here. So what they're saying is what act is actually required under the statute and what intent. Is it objective or subjective intent? Like a normal person would think this would obstruct whatever was going on, or you personally know your intent is to actually obstruct what's going on. And then the act itself is, what exactly do you mean by obstruction? Is going in and forcing them to recess everything an obstruction? And in this guy's case, they were already in recess. So has the act appropriately fit the statute? Corruptly obstructs. Yes. Right. Law, math, exactly. It is. It's difficult, everybody. I think that this is a fair question to ask. I think this petition was incredibly well written, very well written, very organized. Precedent is set out wonderfully. I think they did a good job. Now, what's actually going to happen, that I just don't know. But I think it's been presented quite well. It's going to go... Right. Well, I mean, whatever his intent, if he was physically going to go there or not, what he actually did is his act. So, what he intended to do versus what he attempted to do distinguishes, and why we have 2 charges as well. Yeah, we'll never really know exactly what would have happened. There's a lot of information that we just do not have. We're getting more information every day. I mean, I think today there were some recordings that came out just today of Cheesebro talking about the fake elector scheme. And there's some, audio recording of him talking to Michigan. Every day I feel like more and more comes out constantly. So every day we're adding more to it. And eventually it'll all come out. But, it could take some time. But it's very interesting. It's a very interesting situation. I think it's a valid legal question. I think it's good the court has accepted writs on it. If they had denied cert, they would have just said whatever the lower court said is fine, which would have made things easier. But sometimes, you got to kind of get into the weeds to sort how the law is supposed to be. But that also means there's a little bit of faith that we're supposed to have, I guess. Maybe not faith. Faith isn't the right word. Respect for the Supreme Court, perhaps. Pennsylvania fake electors put in a clause. Yes. Now, Suze, what's so interesting about that, everybody, is that's actually mentioned in the DC indictment. It's also, there's some language of it mentioned in the Georgia RICO indictment as well, where they set out that Pennsylvania wanted this additional language put in there. And that one of the workers had said, don't say this to the other states because they're going to want that language too. Those words are actually, some pieces of that are put into the indictment. So now we're even getting more clarity about what's already out there. Very fascinating situation. Kudos for picking this apart after 1200. True. Although VC2, again, I'm not really sure how many people have actually been charged under 1512. So this was charged, but it wasn't charged in all of them. Now, if you remember a while back, which I'm sure you do, your memory is amazing, but I went through the Jan 6th file and I had about, 2 inches of paperwork going through. And I had highlighted who had been charged with 1512, who had been charged with trespass, who had been charged with not leaving. There had been multiple different kinds of charges. Not everybody was charged with a 1512. So, I think that that's worth noting, that they didn't charge this blanket across everybody. Some of them were charged for sure, but not all of them. Again, just like Trump's got 2 other charges that he's facing that are not 1512. No sticky note tonight. Oh, no, here. There it is. Late sticky note. Oh my gosh, sorry. It's hard to have respect for the Supreme Court these days. Oh, Vic, true story. Absolutely true story. Yep, absolutely. It is. These are difficult times. These are very difficult times when it comes to the Supreme Court. But, it's interesting. It's just spin the wheel. We just don't know what's going to happen. Unfortunately, usually we could predict things. We've had conservative, extremely conservative versus, I don't think we've ever had, actually the Warren Court was seen as quite liberal, even though technically he was a conservative. But, we've kind of gone back and forth, and there were times when the justices almost got into fisticuffs with each other because their ideologies were so different. Do you feel he will be found guilty of any of this prior? Oh, for Trump, Sharon, do you mean will Trump be found guilty? That I just don't know. The way all of this is going, I feel like there has to be a criminal case that will be tried before November. Will it be finished? Will we have a sentencing? Now that I don't know, but I think we will have definitely a criminal case go forward. If we have 2, I think maximum we'll have 2 criminal cases. I don't think we'll have all 4. Yeah, I don't think we'll have all 4. I think 2 is a safe bet. Yep. Strict house arrest. Could be. It could be. Again, that really begs the question, what is the appropriate accountability? What does accountability look like? And also, Judge Chutkin saying, I'm still here. I can still preserve, this whole process as well. So, Okay, did any of the officers, congressmen, and people to sue Trump, or just the U.S. because he was president? Yes, they did sue. So there is a very important case, the Blessing Game case. And let me just write it here. And there's a group of people that were harmed. So Congress people, officers, multiple people involved. So multiple petitioners. And they were just given the green light to go forward. So at first, Trump did a motion to dismiss. That was denied. Then he did a motion to dismiss based off of presidential immunity. That was denied. And Judge Chutkan just used that opinion. So the Blessing Game civil case is going forward for sure. What does whoever corruptly means? Well, that's a great question, right? I mean, that's one of the issues that we're dealing with, is that corruptly. What does corruptly mean? Are we talking about the dictionary definition, the legal definition, the, what exactly? And when we're talking about corruptness, we're talking also about mens rea. So that's one of the big questions in the case. Trump ate my homework. He does eat paper, but I'm not sure. I'm not sure about that. With intent. Yeah. So there has to be some kind of negative intent. Now, I think they talked about, is there this innate maliciousness or evil mindset as part of it? But, I'm not really sure how they're exactly going to define it. And that's one of those issues. It's so clear and informative. Oh, well, thank you, Heather. I'm glad it's helpful. And flushes paper and burns paper. Was it Trump that burns paper? Was it Mark Meadows? I think it was Meadows. Lots of different ways to get rid of paper, people. Oh my gosh, I'm not encouraging that. I'm just saying. Oh my goodness. This will make a great story someday. One thing that isn't corrupt is if it was stupidity or accidental, I think. So, right. And see, corruptly, you make such a good point, because we have all these different levels of intent. All right. So you might think, well, mens rea, we just have intent, but you can have reckless disregard. We can have reckless disregard, purposefully would be one. Oops, I'm not spelling that correctly. Sorry, everybody. Purposefully, intently. So that's another one. Reckless disregard, purposefully, intently. There's all different kinds of ways of looking at it, of looking at intent. So corruptly, again, is just this next level of intent. What exactly that means in this situation. Accidentally muted someone, but have unmuted. Please. Oh, yes, it happens sometimes, Tiffany. Absolutely. We do our best here, but reckless disregard was what Justice Kagan attached onto the Counterman case when it came to stalking. But purposefully, intently, knowingly, these are all different standards that we use. Knowingly, and my spelling is atrocious, everybody. Quick. Oh my gosh. But corruptly is just another one of those elements that will fit under the mens rea category. More interesting question for the average. Yeah, I think it's a great question. What exactly does corruptly mean? And, given the facts of this case where this guy, what was his intent? He was allegedly just hanging out and got pushed into the mess and was actually friendly with the cops. And then things took a turn. So did he even have the requisite intent required under subsection C? So those are great questions that would have to be answered at trial. Now, I had thought he had already been to trial and that we were on appeal, but apparently he's not even been to trial. So I will need to go back and read the other two cases. I have the other two guys' cases that I've gone through, and I thought they had all gone through it already, had been already found guilty. So I will have to go back through and double check that. I had that incorrect. How did he have handcuffs? I think the officers dropped them and he picked them up and gave them back. He left DC and came back. Yeah, I mean, that kind of goes into intent, I think. He pushed his way to the front of the crowd and then got knocked down. Okay, could be. Yeah. Where's your new kitty? Well, She's been she's been booted out of the room for tonight. He joined the riot. It seems like it. It seems like he intentionally was involved in that, again, with whatever level of intent involved here. R v Jackson. R versus Jackson. I know a lot of Jackson cases, but how's the kitty? She's doing okay, everybody. She's sharp, though. Okay, let me see. I don't want to... And I don't mean sharp intelligence-wise, although I'm sure she is, but... She scratched me good. She got me good. She got me good. I was like, just saying, hey, look, I'm your friend. She got me. You know, it's what they do, though. It's her DNA. It's what she is supposed to do. No fever. Nope. Everyone's got shots. Her name is Pearl. Her name's Pearl. Yeah, and she sneezes so much. I think... She definitely has. Oh, yes, definitely wash that. She did. Yeah, she's only been here a couple days, so she's still pretty nervous. And I think I just was too ready to give her love. She just needed, she was like, give me some space, lady. So, yes, kennel cough. I'm not sure. She kind of like hid under an area that had a lot of dust that I didn't realize had a lot of dust, but she's white. And so when she came out, she was gray. So I'm wondering if that's part of it. Yeah, no, Kristen, she'll be inside for good. We have a screened in porch. That's as far outside as she'll go. So, but, oh, really? Oh, I love that. Her name was Pearl also. Yes. Too much cute aggression. But we're so excited to have her. We lost our kitty a few years ago, so now it's clean under there. Well, it is now. Yes, I've been out with the vacuum all day. Oh my gosh. Could you give us your opinion on Jack Smith? Yeah, I mean, I don't know Jack Smith. I know he lost the case against John Edwards. I know he's working his fingers to the bone. So she was helping. I think she was. I am undecided. I feel like I don't have enough information to fully make a decision yet. So jury's out still on him. He's not done anything that I have found offensive at this point, but I just don't have enough information to go off of yet. Will feign affection for treats, true. Runs like a person's cold. Yes. So, yeah, we've got a new vet that we'll be taking her to soon. So, just to meet the vet. Oh, my gosh. Yeah, it's been a lot. But, yeah, but with Jack Smith, I had not heard of him at all, actually, before this had gone on. And then there is another attorney on this app, Dave. I think he goes by Dave the Angry Lawyer. He cracks me up so much. Cracks me up. I mean, he makes me laugh till I fall off a chair. But anyway, so he was telling me about Jack. And I thought, okay, well, that's fun. That's very fun. So I'm learning more about him all the time. I thought Jack's writing was pretty good. I agree. I would agree with that for sure. All great cat. Still trying to figure her out. Oh, that's so fun. Oh my gosh. Yeah, I haven't done a lot of history on his work. I think any work at the Hague's going to be incredibly difficult. I can't even imagine the mental fortitude it would take to do that kind of work. It's one thing to be a prosecutor when, people are making bad choices and they need to go and think about those bad choices for a while. It's another thing to prosecute war crimes. I think it's a completely different mindset and mental fortitude as well. So, yep. But to do that kind of work, it takes a lot out of you. Nothing but respect for everyone working on those sides in those kinds of areas. It takes a lot. So, but for me, nope. I just have a kitty now. I got to take care of my little new member. He doesn't seem like a politician. Yeah, he actually seems to be averse. Like maybe he's allergic. He's just got too much stuff going on. He doesn't have time to mess around with all the bologna sandwiches out there. He's probably learned that in his work to stay focused, stay on the job. that there are so many sets of laws in each country to consider translation customs. Oh my gosh, absolutely, VC, absolutely. You know, I have spent some time going through multiple different constitutions, and I call them constitutions. They're not all called constitutions, but it's fascinating how different the laws are. Yes, if you have to choose, Jim, between the egg or a kitty, choose the kitty. Yes, every time. Yes, well, and I had a really amazing kitty for almost 20 years, and she had passed away, and we missed her, and it was time, everybody. Things are getting a little crazy here. These Trump cases, they drove me to adopt a kitty. I couldn't take it anymore. I was like, this is madness. It's time for a furball. The cheese and crackers. Oh my gosh. Voice typing doesn't always spell right. That's so true. That is absolutely true. You know, that's one of the reasons why I started reading these documents, everybody. To be perfectly honest, I have lots of different apps that read things to me, and I could not find a way to get through these documents, understand what they were saying, and then by the time the next thing got scanned, it was so frustrating. So that was one of the reasons I started reading it, and it was fun because I just turned the camera on and I thought, I wonder if other people want to read through it too. So, does Congress need to know high crime or misdemeanor before conducting an impeachment inquiry? Well, apparently not. I thought you actually had to have one, but apparently you don't. Yeah, you certainly have to have one in order to go forward and convict, or in order to actually impeach someone. But apparently just for an inquiry, you don't have to. How many more felony charges is Trump possibly looking at? Oh, that I don't know. There's a lot of the voter fake electors. I call them fake electors. I don't know what else to call them. I don't want to just call them alternate electors, because that's maybe illegal electors would be better than saying fake. So illegal or undocumented electors, maybe. I just don't know, but they are coming out in more states, so I think we'll see more of that. But as far as Mr. Trump goes, there's some probably still working on it, but I don't know exactly what those cases would be at this point. Fake illegal. Okay. Yeah. I don't know. I don't, 6 here in Nevada. Yes, exactly. Fraudulent. That sounds better. Let's use that. Unqualified, maybe. Okay. I like it. All right. We have fraudulent. Here we go. Fraudulent. Or we have, I already forgot it. Faux. Oh my goodness. That may be the best one yet. The faux electors. Oh my gosh. The very bad type. That's funny. Imposter electors. Well, right. I mean, it just doesn't seem right. Imaginary retroactive. Oh my gosh. Y'all are so funny. Oh my gosh. Oh, you're taking your crim law final on Friday. Oh my gosh. Best of luck to you. Unconstitutional. Oh my gosh. Redheaded one. Best one. Unconstitutional. Unconstitutional electors. I think that might be the winner. I don't know, actually. I don't know. We'll see. Okay, electors. Well, I wish you lots of luck. We've got, with finals going on, cosplay electors. Just remember to review your outline and get it down to 1 to 2 pages, and you will be just ready to go. You will be good to go. And don't remember your IRAC, right? So issue, rule, analysis, and conclusion. So follow your format for each of your issues. Circle your issues before you get started. The unknowns. Oh my gosh, that's so funny. Yes, take care, Tyler. Best of luck to you. Really, I'll be thinking about everyone. Really? LARPing electors? Oh my, right, I react. That's exceptional. That's exceptional. I'm adding that right now. That's going to be my new thing now. I react. I love it. Irregular. Lopsided? I don't know, everybody. How about untrue? Untrue electors. Oh my gosh. Yes. So with all of them, outlines should have started week 5. Well, some people, that didn't work for my personal style because I'm such a visual person. So I always went, the last few weeks was it. I'd make a 100-page outline just a few weeks before finals. Then I would cut it down to 50, cut it down to 25, cut it down to 10, cut it down to 5, and then cut it down to 1.5. But that process, I started much closer to finals. Some people did start at week 5, and I think that's fantastic. I think that's really great. That just didn't work for me. I needed to really condense it in a short period of time. Irregulars. Oh, dear. I'm not sure. Oh, my gosh. Oh, that's so funny. That's very funny. Week 1 started then. Well, that's a great way to do it too. I mean, to each their own. Everyone's got their own style for sure. I remember too, I kind of would get a little loopy. I know, imagine that. But I would get a little loopy and I made a lot of different posters and board games with the content. Just any way I could work with the content that wasn't boring. I was in there. Really, Nevada teaches a course on constitutional law. Oh my gosh, oh my gosh, that's even worse, isn't it? Then they should have known better. Shame, shame, shame. Factory seconds. Oh my goodness. Figment of your imagination. Do-over liners. Lumpy pillow electors. Poster boards, whiteboards. Yes, absolutely. You got to put those up all over the place. Get those outlines on a sticky note. You can do it. Illegitimate. Yeah, I think illegitimate's pretty good too. Although, I mean, rejected. I don't know. I kind of I like all of these. These are all great. Counterfeit. Yeah, that's a good one. That's a good one. Oh my God, it's constitutional law part of law school. It is. It's split into 2 pieces, Kristen. So for constitutional law, we've got 2 semesters. One is going to set out the actual articles, like the design of the Constitution. So the branches of the government and so on. And then the second piece will go through the different amendments. So because we're split, we have 7 articles. So we study each and every single one of those articles, what it means, jurisdiction under Article 3, all of those kinds of things. And then we get into more of the fun stuff like First Amendment, Second Amendment, and so on. So they have to split it into 2 parts typically. Had to learn business law. I'm so sorry. I'm so sorry, Corey. 20 years to life electors. No! That's a tough one. Oh my gosh. Who's the main architect of the fraudulent electors? So, okay. So my understanding is that it was Eastman and Cheesebro. So Eastman really started it. Yeah, Marbury v. Madison. Exactly. Felonious electors. Oh, that's got a nice ring to it for sure. Yeah, Eastman and Cheesebro. Although the more I listen to these recordings of Eastman, the more it's like, wow, he really messed up. And he realized it too. He was like, whoops. And one of the portions of the recording, he was saying, well, I guess people got upset about this, so I guess I could have done that better. I was like, you think so, dude? Oh my gosh. From Eastman. Yes. Yeah, he messed up bad. He messed up real bad. I mean, it's one thing to go in and, be like, hey, I'm a lawyer, listen to me. But it's another thing when you're trying to circumvent an election. That's a lot. So with that, everybody, I'll give you one final story, one hilarious anecdote before I sign off for tonight. Speaking of which, I had a moment, I have to admit, I had a moment at my pharmacy today, all right? And I like to call this a cheese bro moment now that I think about it, because it was like a moment where things could have gone bad, but yet I made a good choice. So here's what happened. So I went into my pharmacy to get some medication that's completely whatever, just regular medication. I went in and I picked it up. I filled out whatever. I paid for it. And then the cashier person held on to the prescription and said, the pharmacist needs to talk to you. And I said, well, I've been taking this for 15 years. So I don't really need to see the pharmacist, in a polite voice, because it's the holidays, people. And the cashier was holding this like a death grip because I was trying to reach through the window and she was like pulling it further away. I was like, give it to me. And she's like, no, you have to talk to the pharmacist. And I'm trying to get it. And she's like, no. And so I said, no, just give it to me. What are you doing? And she's like, you have to talk to the pharmacist. And I asked her, I said, well, why? And she said, because it's the law. And I said to her, and I don't know what happened, but her head just exploded. I said to her, I am a lawyer. There is no law that's requiring me to stand here and wait for the pharmacist to talk to me to get my medication. And she said, what? You're a lawyer? And I was like, yes, I am. And she's like, well, and so she retreated further back behind the glass. And then still had my little medication, walked over to the pharmacist who had like 5 people in line because there was some problem with their computers that said everybody had to get a consult. But I was still reaching my hand through the window trying to grab it. And I kept saying to her while I was doing this, I was saying like, cite me the law, cite me the law. And she finally just pulled the pharmacist and was like, give her the medicine. And the pharmacist is like, is this new? I'm like, no, it's not. What more are you talking about? Give me my stuff. So anyway, the pharmacist just threw it through the window. And I said, thank you kindly. And off I went. Is this the real reason? I have a scratch on my arm. No. Although it would make sense. But this is how my day's been, people. I mean, I don't like to pull rank, but I was like, there's this huge line of people because their system got messed up. And she was like, well, it's the law. And I just, for some reason, was like, that's absolutely not true whatsoever. Anyway. Oh my gosh. All right. Everybody made it out okay. Then after that, and I told my spouse about it, and he's like, seriously, I said I would go pick it up for you. Oh my gosh. Yes. So, well, I mean, she's just doing her job, so of course she can't get angry. So I just felt if I could just snatch it from her. I was like, what are you going to do? Call the cops because I'm taking my own medicine? Come on. Anyway, so that's my funny anecdote for the day, everybody. Oh my gosh. Yes. So I will be off tomorrow with new holiday hours, but I will be back again on Friday, everybody. So, well, yeah, I was just saying like, well, what law are you talking about? I had my phone out and I'm like, I'll pull that law up right now. Oh my gosh. Oh my gosh. Yes, indeed. But thank you all for joining me tonight. As always, it's always fun to hang out and talk about these fun things. Yes, the ethics talk is coming soon. I'm still waiting on my book. I should get it very, very soon. So I don't know. I'm thinking about taking her like a little thing of candy, but like as a peace offering. But we'll see what happens. Anyway, best of nights to all of you. Take care, everyone. I will be back again very soon. Thanks again for all your time and support. All right, off I go, everyone. Have a great night.